Okay, so let's start by talking about some key topics, some key terms and concepts associated with land tenure. The first is, what does this mean? What does this phrase land tenure mean? Well, it's typically described or defined as a relationship among people with respect to land itself. So tenure can be either determined by a formal relationship with the state, or it can be defined through customary and informal relations people might have on the ground with traditional leaders. The relationships that you can have can certainly be between individuals, or they can be between an individual and a group, or they can be between individuals, groups, and the state. And typically when we talk about land and tenure, there's a web of relationships that exist around the tenure situation. So I'd like to actually give you an example to explain. Assume you're in a country, maybe it's a developed world country, and let's say you own a piece of land. Owning a piece of land usually means that you have relatively exclusive rights over the way you can use that land, and we'll talk a little bit more about the rights as we go on. But your tenure in relation to the land is, if you're an exclusive owner, that you have something called a freehold ownership stake in the land. You, in relation to other people, you are the person who determines how the land can be used. You're the person, with some exceptions, ownership rights over land are never absolute, but you're the person who's going to determine where, say, to build a structure on the land, whether or not to plant trees on the land. Your tenure is very robust, it's very strong. If, on the other hand, you have a leasehold tenure over that piece of land, you may be able to make a lot of decisions around the land, but there's one key decision you can't make. You can't make a decision about selling the land because someone else, the person from whom you've leased the land, is the person who makes the decisions around selling or mortgaging even that piece of land. So your tenure relationships are a set of relationships that you have with regard to other people about a particular piece of property. The rights you have over that piece of property derive from your tenure relationship to other people and your tenure relationship to the land. It's important to note that tenure rights or tenure categories exist along a continuum. And so the slide that you see here identifies the continuum of rights that we'll oftentimes talk about when we're discussing land tenure issues. So you see on one side of the slide that there can be informal tenure rights, and on the other side of the slide, at the other end of the continuum, there are formal tenure rights. Informal tenure rights might be as completely informal as I walk onto your land and squat there. That's an informal right. No one's given me officially the right to be there. Even under a customary system, if I walk onto your land and squat on that land, unless a traditional authority recognizes my right to be there or subsequently grants me the right to be there, my right is a very informal right. And you can see along this chart that there are different types of tenure associated with different levels of formality and informality. So at one high end of formal land tenure rights are registered freehold rights, those really exclusive sets of rights we talked about earlier that are recognized by the state, usually with a piece of paper, a document, or increasingly in some digital form. And again, at the other end, very informal rights, which could be something like a pavement dweller, say, in an urban slum setting. It's important to say that although these rights exist on a continuum, it may in any given situation be the case that one kind of tenure is useful or good in a kind of subjective sense, or good enough to provide protection to the people who hold that tenure. So let me give you an example. Even though customary tenure is down on one side of the spectrum towards informal rights, don't assume that because it's towards informal rights that necessarily means it's bad. The land tenure sector has increasingly come to the recognition that even informal rights can provide sufficient protection for customary tenure holders if those rights are recognized and if those rights are enforceable. So customary tenure that covers a group of people and that has clear rules and is enforced against others, can provide enough security, and we'll talk about this in a moment, can provide enough security for that group to protect its land, invest in its land, and conserve in its land. So what are the different kinds and varieties of tenure or land rights? Well, you can see on this slide that there are a variety of different categories of tenure. And you heard from the last lecture, and you'll hear again in the economic growth lecture, that these different kinds of tenure, private tenure, communal tenure, state and open access tenure, they evolve over time. So land is not a static sector. It's a sector where relationships among people with regard to a natural asset change over time. Why would tenure relations change over time? A couple of reasons, and this would be consistent whether you're in North America, Europe, Africa, or Asia. Once populations start rising in an area, land becomes a scarcer asset. Scarcer assets usually become more valuable, and it becomes worthwhile for people in situations where land becomes a scarcer asset to take the time and expend the resources necessary to more carefully define rights over land. And so what you tend to see in areas where population rises and where you go from a situation of land abundance to more land scarcity, you see the land situation, the tenure environment evolving from communal lands or common lands towards an environment where people hold individualized rights to land, more like a freehold situation. And that happens because people are trying to, in economic terms, internalize the returns that can come from protecting and investing in a particular piece of land. Sometimes, though, land tenure categories change or evolve because there are new technologies. New technologies could involve things that reduce the costs of defining or enforcing property rights. Those are two typical ways in which, or two typical pushes that help land tenure categories evolve over time. I'm going to talk a little bit more about these different types of tenure because you will have heard, if you're in the development space, you'll have heard about many of these different types. So there is a category of tenure that's associated with private ownership. Private ownership can be individual. I can own my house. But private ownership can also be associated with a group. In many cities, groups own condominiums, for example, or groups own cooperatives. Communal groups in rural areas might, in a sense, be considered a larger variety of private land holding. There's also corporate tenure. So if you're a legal entity and you as a legal entity own an area of land, that's a private ownership form. As long as the rights to your tenure are recognized and enforced, it can be a very secure way to hold land and other assets. People will oftentimes contrast private ownership with communal ownership, but I was just really making the argument that communal ownership might actually be seen as a different kind of private ownership. Usually the ownership is over a common area. Maybe it's over a forest, maybe it's over pasture lands, maybe it's over a water source, but it's a group of people who have those rights to use, extract, manage, and benefit from those resources together, sort of jointly and severally in Anglo-American legal terms. They can use the resources together. Normally, in a communal tenure environment, there will be customary rights that have evolved over the course of time to control how you access those resources. Who gets the rights to go in and gather firewood, for example, in a communal forest? Those rules will have been decided over the course of long periods of time, and they're designed to ensure that people normally don't overuse the resource. And those rules will be enforced in a customary manner, usually by some consensus-based decision-making system, as opposed to in a formal court of law. Normally, communal rights, I mentioned this earlier, normally communal rights can't be sold. So we'll talk about sticks in a bundle of rights in a few minutes, but what typically is most characteristic about communal rights is not so much whether it's private or non-private, it's whether the assets can be sold to an outsider or not sold to an outsider. Communal land systems oftentimes will allow other people to borrow land. They might allow other people who are outsiders to come in and use land, but typically can't sell the land outright. And there's a good reason for that. Communal land systems provide a social security net for societies. You may talk about this in a little bit more detail in the food security module that you have. Okay, so you have private tenure, communal tenure, and then state tenure. This is a really important tenure category throughout the world. In the United States, for example, a third of the landmass of the United States is owned by the government, different levels of government, the federal government, state governments, local governments. State land, when you have a state land environment, the state holds the ultimate title to the land. It's usually, though, a much smaller percentage of land held by the state in the developed world than in the developing world. So in much of sub-Saharan Africa, for example, all land is held by the state. The state's the ultimate title holder, and the state will lease out or recognize rights that communal groups have, or they'll lease out rights, sometimes long-term, sometimes short-term rights for people to use the land. State land is the default ownership category, of course, in socialist or formerly socialist states, Vietnam, for example, Cambodia and Laos. And then finally, there's this fourth category called open access, or res nullius. Open access territories are places where nobody controls the property, and the classic example of an open access resource would be the high seas. Nobody, no state, no international entity controls or has ownership claims over the high seas. It's a thing that's not claimed by anyone, so a res nullius in legal terms. Okay, so here are just a few additional terms. We've already mentioned some of these, but you may have heard of, and you may encounter in some of your development work. So the first is freehold or fee simple ownership. This is when, as I mentioned earlier, an owner has a very robust, very full set of rights over a particular parcel or piece of land. Rights to control the land, use the land, and transfer the land. Always, again, subject to some rules and regulations or some legal principles that the government can impose. So you never have the right to, under legal systems, do harm to other people. All legal systems constrain your right, even as a fee simple freehold owner. They constrain your right to harm your neighbors. The government almost always, I can't think of an exception, the government always holds the right to eminent domain. How eminent domain gets interpreted, though, is very different from country to country. In some places, the government can only take private property for a use if the government can show that the taking serves a public purpose. Public purpose can be interpreted very differently. Some countries have very broad interpretations of public purpose and might include, say, economic development. I might transfer your land to this person over here because they're going to build a factory, and that's deemed to be a public purpose. In other societies, though, public purpose isn't defined quite as broadly, and public purpose might include things like, I may take your land, and I may use it over here to build a road that's going to broadly benefit more of society. So eminent domain is a very important power that states hold. Again, gets defined differently in different locations. Leasehold rights are extraordinarily common. They're extremely valuable. Having the right to lease out land or lease in land is helpful for people who, say, are farming. And maybe, let's say, maybe I'm a farmer, maybe I have 5 hectares of land. If I'm an extremely efficient farmer, it might be to my benefit to lease out the 5 hectares that my neighbor has. If I have good leasehold rules that are clear, that are enforceable, I may be able to consolidate my holding with my neighbor's holding, grow more. If I'm an efficient producer, I can produce more for market, benefiting myself, my family, maybe creating some jobs for other people. So leasehold is a right to use land or real property for a particular period of time, a defined period of time. Leaseholds, of course, like any property right or a tenure right, can either be formal or informal. So we may just agree, my neighbor and I, we may agree to an exchange where I lease her land for a period of years, or we may actually sign a formal contract that can be enforced at law. Usufructuary rights are not so commonly referred to in Anglo-Saxon jurisdictions, but in civil law jurisdictions, usufructuary rights are very commonly referred to. They're the right to use land or a resource. The important point here is the final bullet, really. It's not the case that any one of these types of rights is necessarily better or superior than to the others. Let's think about maybe an example, a piece of movable property. You might decide that you want to purchase an automobile so that you have transport whenever you need it. On the other hand, there may be situations in which it makes perfect sense for you to rent an automobile. Having that limited, that opportunity to use a car for a limited period of time, maybe you're visiting another city, can be really useful to you. Similarly, you may be a farmer who wants to lease a neighboring field for a period of years. Maybe after that period of years, you're going to get too old, you're not going to want to farm as much anymore, and you don't want the burden and associated costs of having to maintain a large parcel of land, but a small parcel with additions from leaseholding can be a really efficient, valuable way for you to achieve your economic ends. So important, no one of these rights is superior to the others. They are beneficial in different situations. And so as a development professional, you need to think about the situation that you're trying to address and think through which one of these kinds of rights is going to be useful to accomplish your programming goals. Okay, let's talk about land governance for a few moments. In the previous module, we talked about why land governance is important, and we talked about the fact that land professionals increasingly use the phrase land governance. So you can see the definition here. It's the whole structure of rules, processes, and institutions that are making decisions about how to allocate land, how to transfer rights to land, how to enforce these rights, and how you sanction people, how you impose penalties when people violate the rules. Land governance you might think of as a subset of governance writ large. We spend a lot of time in the development sector thinking about governance, and good governance particularly. More recently, we've been spending time in the land sector thinking about land governance. Because land and natural resources associated with land are so critically important to promoting economic development, we want to make sure that the systems that govern the use of these resources are transparent, accountable, accessible, and relatively equitable. So land governance systems can be constrained in ways that more traditional political governance systems can be constrained. They can be constrained by corruption. They can be constrained by lack of capacity. They can be constrained by people just not understanding, lacking awareness about what the system entails. So at the international level, there's been a strong movement over the last 5 years or so to create some documents that provide states, private sector investors, and local host governments as well as CSOs with guidance around how to improve land governance. And you can see some of these documents are listed on this slide. So the most important of these are the voluntary guidelines on the responsible governance of tenure of land, fisheries, and forests in the context of national food security. So that's a really long title. We usually call them the VGs or the VGGT. This document was negotiated at the Committee on World Food Security and endorsed in 2012, and really represents the first international level agreement on what it means to do a good job managing, allocating, transferring land rights at the national level, and then provide some good guidance to international investors as well. All right, now I'm going to dive a little bit deeper into the distinction between formal and informal land governance systems. So a formal land governance system is basically the state system. It's what the government is doing in order to allocate land, manage land, oversee the transfer of land, and then provide sanctioning mechanisms where they're needed. So formal state institutions that deal with land governance will include things like a land administration office, Some countries have land ministries. Sometimes the land offices will be found inside other ministries. In some countries, the land office will be inside the agricultural ministry, for example. But as well, there'll be formal rules written into constitutions or written into statutes and regulations that govern tenure relations and property relations amongst people. If you're in a formal system where you have these kinds of formal rules, statutes, constitutional provisions, when you transfer land or when your use of land imposes harms on other people and people are bringing a claim against you, you'll typically end up in a court, usually a trial level court, to decide who was right and who was wrong in that situation. All of these institutions are designed to promote the efficient transfer of property from one user to another. That's kind of the core of a formal land tenure system. The idea here, if you're familiar with the economics of it, is that we want to facilitate land being used by the highest value user, whoever that highest value user is. And voluntary transactions will support transfers that lead to the highest value user having control over land. So, an example. If I sell my home to somebody in a voluntary exchange, presumably the other person values the home more highly than I do because they're willing to pay a price and I'm willing to accept a price for that home. If the other person offered me a price that was too low, I wouldn't sell the house. I would remain the highest value user of the house. But if I sell in a voluntary exchange, the idea anyway is that the asset has transferred to someone who's going to value it more highly and put it to productive use. Okay, this system of transferring property in the developed world especially is supported by a whole cadre of professionals. It's supported by lawyers, specialized lawyers called conveyancers, surveyors, assessors, real estate agents, and mortgage bankers. That's a very significant portion of folks in an economy who are all focused on ensuring that property transfers effectively, efficiently, relatively transparently from one holder to another. The important thing here is that much of our development work over the past 30 to 40 years has really been focused on helping this system to improve in the developing world. So helping build the capacity of land administration offices or ministries. An example might be U.S. aid support, for example, to Liberia and to the Land Commission in Liberia over the past several years. The idea there has been to build the capacity of the Land Commission to enact laws, to recreate a registry, to rebuild a registry that was damaged during civil war, with a goal of ensuring that property transfers effectively and efficiently among users in the formal sector. Let's contrast that now with the informal land governance system, and we've mentioned this already. The informal land governance system is really a pretty robust, very, very sophisticated in many environments, set of non-state institutional arrangements that allocate land and that allocate other resources found on land. So these non-state arrangements can be customary or informal. They can take the form of religious institutions that allocate use rights or that transfer the ability to use and benefit from land and resources. Some typical characteristics of informal land governance systems or institutions is that the rules will not be written down. They're not going to be codified in a statute or a regulation. Religious systems may be a little bit different. But a traditional customary system is not going to necessarily have written down rules. There's not going to be a book you can go pick up and look up what's the rule here in this environment. Rather, the rules are going to be in the traditional authority's mind. They're going to be passed down from one leader to another leader over the course of time. This system also doesn't have the same sort of support network of professionals that the formal system has. So you're not going to find professionally trained surveyors or real estate agents or mortgage bankers in these systems. And so another emphasis of development programming over the past number of years has been to think about how can you help facilitate effective transfers and how can you improve accessibility, how can you improve transparency when systems are customarily based rather than based in the formal sector. Okay. Relatively little attention from the development community has been paid to the informal land governance systems around the world. There's been a lot of emphasis on taking these systems and formalizing them, bringing them into that state-oriented, state-controlled system, but less emphasis on maybe leaving them where they are in the informal sector, and there are good reasons for that. We'll talk about those in a few moments. But I do want to share with you one example of some attention that USAID has been giving to informal land governance systems, and that's taking place in Ethiopia, where under a new land program, which is actually called LAND, the USAID is working with pastoral communities in parts of Ethiopia where there are larger communities of pastoralists, the east and the south, to help those communities identify, demarcate, and then register their claims over pasture lands, migratory routes, and water sources. And so that's an attempt to recognize what's existed customarily and give it a little bit more protection by identifying boundaries and claims associated with those informal governance systems over pastures and waters and these routes to move. So that's kind of a long explanation of tenure and different tenure systems. And we took that much time to explain this to you because it's really important to understand what tenure is. And you can see on this slide a number of reasons why it's important to understand this concept of tenure. Many economists will talk about property rights or land tenure, I'm going to use them interchangeably here, as one of the foundational institutions for economic growth. You cannot get sustained, widely beneficial economic growth unless you have some security over property and by extension then some security over land resources. So why is land tenure so important? Because A, land and resources are valuable. The value that they represent equals power for the people who control them. The ability to make decisions about who gets to use, who gets to benefit from land and natural resources provides the allocator with some important political, social, and economic power. The kinds of tenure that are available to people then in turn can influence economic growth, and it can significantly influence empowerment, especially for women. The ability to manage land tenure relations, the ability of a government especially to manage these relations can significantly impact the level of social conflict within a society. So let's say you live in a society that has a formal land governance system, but the government, for whatever reason, it lacks capacity, it's a society where elites are protected and others aren't. If the system is a formal system, but the government doesn't enforce rules or doesn't enforce rules in an impartial manner, that can significantly drive conflict between neighbors. It can drive problems like land grabbing, which can raise conflict levels more broadly across the society. A couple of other ways in which land governance is important and tenure is important. You'll hear in the discussion that we have around economic growth and around food security that having some real security over the land that you farm, having a real claim over your field, feeling that it's yours and it's going to be yours for a period of time, is one of the important incentivizing factors that will lead you to invest in that farm, and that in turn can raise agricultural productivity and food security. Having that sense of security, though, can also help reduce problems like deforestation.